Hello and welcome to the channel. It's me, Kristofer Brooks. I hope everyone's keeping well and I hope everyone's enjoying their weekend. Okay, so I've come up with a rebuttal for the 12 Presumptions of Law. Now, it is simplified. It's not 100% perfect. There's some errors in it. But I'm not doing this to send off. I'm just doing this to learn, and so I'm kind of showing you my progress. Really, it's not a tool for use. If you can find use with it, fine, but it's not a tool for use. And see, I know this is going to really boil the from one person watching this. I'm surprised he still watches my channel. And I have to say, I do really enjoy the way he writes things, and I really enjoyed listening to some of his stories because he made me laugh. But yeah, that's just by the by. So yeah, I'm just playing around really, and so this is the 12 Presumptions of Law rebuttal. Really simplified. Like I said, there's a couple of mistakes in it, but it's just a bit of fun. So yeah, let me know what you think in the comments. Look after yourselves, take care, speak to you all again soon.
Affidavit of Truth. Rebuttal of the 12 Presumptions of Law. Joe Bloggs, a living man. All rights reserved, without prejudice. I. Affidavit of Fact. I, Joe Bloggs, a living, breathing man, competent to state the facts herein, declare under penalty of perjury that the statements made in this affidavit are true and correct to the best of my knowledge and belief. I make this affidavit in rebuke and rebuttal of the 12 presumptions of law that are unlawfully imposed by the legal system under the assumption that I, Joe Bloggs, have knowingly, willingly, and voluntarily agreed to these presumptions. Since these presumptions lack lawful standing unless accepted, I formally reject, refute, and rebut each of them. 12 Presumptions of Law rebutted. 1. Presumption of public record. The assumption that all cases in court are public record, unless explicitly rebutted, is false. Courts often operate under private bar guild rules, treating proceedings as contractual unless challenged. Case law, DPPV Meaden, EWHC 4157. Jurisdiction must be established, not presumed. Rebuttal. I, Joe Bloggs, do not consent to my matter being a private bar guild proceeding and declare my case a public record under common law. Further evidence. Judicial Review Guidance, UK Courts 2. Presumption of public service. It is presumed that judges, magistrates, and prosecutors act as public officials, yet they operate under private bar guild oaths. Case law, Halsbury's Laws of England, 5th edition, Volume 1, Para 10, confirms that public officers must serve impartially, not under private allegiance. Rebuttal. I, Joe Bloggs, formally reject this presumption, as court officials serve the bar, not the people. Further evidence. UK Parliament, Judicial Conduct Rules 3. Presumption of public oath. The assumption that court officers are bound to their public oath of office is misleading when their primary allegiance is to the bar guild. Case law, R.V. Sussex Justices, Ex parte McCarthy, 1924, 1K 256. Justice must not only be done, but must be seen to be done. Rebuttal. I, Joe Bloggs, challenge the validity of any judge or prosecutor who does not prove allegiance to their public oath over the bar guild. Further evidence. UK Judiciary, Oath of Office. 4. Presumption of immunity. This presumption asserts that judicial officers are immune from personal liability for their actions. Case law, Siros v. Moore, 1975, QB 118. Judges are not immune if they act outside lawful authority or in bad faith. Rebuttal. I, Joe Bloggs, formally rebut this presumption and hold all officers personally accountable for misconduct. Further evidence. Judicial Misconduct Reports, UK Courts. 5. Presumption of summons. A summons is presumed to confer automatic jurisdiction, yet it requires voluntary consent to be valid. Case law, Henderson v. Henderson 1843, 3 Hare 100. Jurisdiction must be proven, not presumed. Rebuttal. I, Joe Bloggs, formally reject any assumption of jurisdiction unless the court provides lawful evidence proving jurisdiction. Further evidence, UK Courts, Jurisdiction Rule 6. Presumption of custody. This presumption asserts that by appearing in court, one voluntarily consents to custody. Case law, RV Governor of Brock Hill Prison, Ex parte Evans, 2000, UKHL 48. Wrongful imprisonment is unlawful, even under legal error. Rebuttal. I, Joe Bloggs, do not consent to unlawful custody or detention. Further evidence. UK Supreme Court Case Law on False Imprisonment 7. Presumption of Court of Guardians. This presumption treats individuals as wards of the state, making the court a legal guardian over them. Case law. In Ref, Mental Patient Sterilization, 1992 AC1, competence must be proven, not presumed. Rebuttal. I, Joe Bloggs, am competent and do not require state guardianship. Further evidence. UK Mental Capacity Act 2005, 8. Presumption of Court of Trustees. Courts presume all defendants act as trustees, subject to fiduciary obligations. Case law. Barclays Bank v. O'Brien, 1993, UKHL 6. Trusteeship requires explicit consent. Rebuttal. I, Joe Bloggs, am not a trustee and have not consented to any fiduciary role. Further evidence. UK Trustee Act 2000. 9. Presumption of government as executor and beneficiary. This presumption assumes the state acts as both executor and beneficiary in legal matters. Case law. Lloyds Bank v. Rossett, 1991, 1AC 107. Executor roles must be explicitly agreed upon. Rebuttal. I, Joe Bloggs, am the sole executor and beneficiary of my estate. Further evidence. UK Probate Law 10. Presumption of agent and agency. By appearing in court, individuals are assumed to have appointed the judge or prosecutor as their legal agent. Case law. Halsall v. Bryzell, 1957, CH 169. Agency cannot be implied, it must be explicit. Rebuttal. I, Joe Bloggs, have not appointed any legal agent. Further evidence. UK Contract Law Principles 11. Presumption of incompetence. It is assumed individuals do not understand the law, requiring representation. Case law. Wilmington v. DPP, 1935, UKHL 1. Competence is assumed unless proven otherwise. Rebuttal. I, Joe Bloggs, am competent and self-representing. 12. Presumption of guilt. This presumption reverses the burden of proof onto the accused. Case law. Wilmington v. UKHL 1. The burden of proof is always on the prosecution. Rebuttal. I, Joe Bloggs, demand presumption of innocence until proven guilty. 3. Final declaration. I, Joe Bloggs, rebuke all 12 presumptions of law and demand that my rights under common law be upheld. Signed and sealed. Joe Bloggs, attorney in fact, not the trustee. Date.